Good morning, Ram. Hope you're well. Friday the 13th. Welcome to Law for Non-Lawyers, Part 1, Introduction to the Common Law of England and Wales. So I wanted to start today with the Norman Conquest, 1066. And we're going to cover the feudal system and then the notion of parliamentary sovereignty. We're going to have a look at the Magna Carta, a key British legal document that is so key. It's key to the common law system. So even here in Australia, the Magna Carta, the impact of it is hugely relevant. So it's probably the most single important legal document in the history of the world ever. So it's a big deal. So we'll have a look at that and why it wrestled power from the hands of a monarchy into the hands of the people, parliamentary representation, and gave birth to the doctrine of parliamentary sovereignty, which we'll look at today. Encapsulated in that, we will try and explain the UK Constitution, an overview of that it's an unwritten constitution. But I think the best place to start is 1066, William the Conqueror. So I'm just using new technology today. There we go. So 1066, William the Conqueror, France invades England successfully. The Battle of Hastings, for those young historians amongst us who may remember the arrow through the eye. And essentially, I want you to think about if you have all the power. If you have all the power, how do you rule? It's a very tricky thing, monarchy. Everyone wants to kill you. That's why the throne is at the back of the room against the wall. You have guards. You're elevated. People come close, they bow. So you can see they've got no weapons and they're not going to kill you. You often had food tasters to make sure no one was trying to poison you. So you've got all the power, but it's very difficult to then govern down. How do you administer power through your population? It's a real challenge. The diagram on the right shows us in the feudal system, the idea was to delegate power down the structure. The king would have barons, so it's quite a military structure. Under that, you'd have more knights, and then at the bottom was peasants. And the main idea was to give out land, and what land, exclusive possession of land, and to use the land as a generation vehicle to generate products. So this in turn gives loyalty because you're giving something in return, and in return you took taxes from any products that the land gave. So you delegated power down and you've bought loyalty. And this was the beginnings of the law in England. So you then have a system whereby there are some rules in place whereby certain taxation requirements need to be met. And this gives rise to landlord and tenant, which is still obviously in operation today as the two essential ways to own real estate, freehold and leasehold. So by giving out possession and essentially rights over land are all grounded in exclusive possession, the ability to exclude the world, hence front doors, hence fences, hence gates. And by giving possession, you are giving a right over the land. And we did talk in the introductory session around how Indigenous populations find that concept ridiculous. How could anyone own land? Land outlives people. So not so in the common law system, whereby we do give ownership and property rights in the real property to owners, and they hold it either as I said, landlords, or they give leases or licenses to leaseholders or licensees, and they then can occupy the land. So with a leaseholder, you'd have exclusive possession and the ability to exclude the world, even the landlord themselves. So we've got a pyramid structure of power, delegation of power, loyalty backup, people scratching backs and feathering nests, and obviously at the bottom was the lowly peasants. So I show you that to frame the next thing I'm going to show you. So we had a monarchy, an absolute monarchy, and I love this video from the Australian Human Rights Commission, which explains Magna Carta, the relevance, and I think it's very useful for our context because it'll frame the giving or wresting of power from a monarch to the people. So let's have a look at this. Now, is that audio going to work? No. So I'm out of there, and instead I'll put it here. Let's try. This way.
It's an 800-year-old document, written on dried animal skin, in England, on the other side of the world, in a language we no longer use, that most people couldn't read even back then. So why is Magna Carta important to us in Australia today? Because it was the starting point for some of our most important human rights, things it's easy to take for granted. For instance, before Magna Carta, life was pretty cruisy. If you were a king, you could get away with all kinds of things. Owning your own armies, invading other countries whenever you fancied, and taxing people to pay for wars without even asking. Now, there were laws in those days, but some rulers believed they had absolute power and simply ignored them. That changed in 1215, when a group of landowning barons finally had enough of King John's behaviour. They decided the king governed by their consent, not just because he was king. So they got together and forced the king to agree to limit his powers by signing Magna Carta. It was the beginning of fairer rights for the people. The king also agreed he couldn't just add new taxes. Free men had to be represented by a common council to be taxed, which started the evolution of democracy. It also meant the king was no longer top dog, because above him now was the law. Or at least that was the idea. Kings and queens had a lot of trouble getting used to not being in charge. But over the next few hundred years, people power, in the form of Parliament, grew to be much stronger. In its Bill of Rights of 1689, the English Parliament formally decided it was the job of government to represent the people and protect their rights. These ideas came to Australia in English law. We know today if someone is accused of a crime, they have the right to a fair trial, and they must be proven guilty before they can be punished. Before Magna Carta, justice wasn't always applied fairly. Remember old King John? He was pretty good at filling up the prisons. But under Magna Carta, it was no longer up to him to decide whether someone had done wrong. It said, "No free man shall be seized or imprisoned, except by the lawful judgment of his equals or by the law of the land." Now you had to have a reason to lock someone up, and later people decided you also had a right to argue your case in front of a court. But in 1215, no free man didn't mean everyone, because in those days most people weren't free. They were poor peasants who served the lords. It took till the 16, 17 and 1800s before all men were free in Western countries, and most women waited until the 20th century. In 1948, after the atrocities of World War II, the nations of the world created the Universal Declaration of Human Rights. For the first time, the whole world recognized that everyone, it didn't matter who you were, had the right to enjoy freedom of speech, freedom of religion, and freedom from fear and want. It has been described as the international Magna Carta for all mankind. So, this faded old piece of animal skin has played a big part in shaping the democratic society we have in Australia today. But many people around the world are still denied their rights and freedoms. This reminds us human rights shouldn't be taken for granted, and until they are, the long story of human rights and freedoms that began with Magna Carta will continue.
Isn't that excellent? I thought I'd show you that because I couldn't have done it any better myself. So, we've got this notion then of rights, and the power was finally wrestled off of the king and gave birth to Parliament, and now enshrined is parliamentary sovereignty. And I've got a very good quote by A.V. Dicey, who talks about parliamentary sovereignty, and it's so fundamental. So the principle of parliamentary sovereignty means neither more nor less than this, namely that Parliament, thus defined, so a lawfully constituted Parliament, under the English Constitution, has, under the English Constitution, the right to make or unmake any law whatever. And further, that no person or no body is recognised by the law of England as having a right to override or set aside the legislation of Parliament. So we need to ram a peg in the ground here. This is a real cornerstone, that parliamentary sovereignty is sovereign and wrestled and has the power. Essentially, not the monarch is not sovereign. So in the UK, parliamentary sovereignty is sacrosanct, as it is all around the world that has inherited the common law system. And this is really important to us because what this does is it provides an ultimate lawmaking body. The buck stops somewhere, and that is decided in a common law democracy that the buck stops with Parliament. And it also sets up a beautiful dynamic between the legislature and the courts. So we're going to see in a moment through the doctrine of separation of powers about how you go and administer laws, that there are different bodies, if you like, who are responsible for administering different bits of the common law system. However, there is a hierarchy. And prior to Magna Carta, the top of that hierarchy was the monarchy. But as we saw, that does give rise to a plethora and a multitude of issues, mainly egotistical power abuse, which we still see today in jurisdictions that don't spread the power through a democratically elected House of Representatives. All right, which may explain certain behaviours on the world stage. So the idea is that democracy is a great system of having checks and balances on powers so that no power is ceded absolutely, because as we know, absolute power can corrupt absolutely. So we now understand that the power has gone from the king to the people, and over time the legitimacy of Parliament became stronger and stronger, and now I think it's fair to say is sacrosanct. And there's a beautiful interplay between, therefore, the the legislature generating legislation, acts of parliament, which we can find, they're public documents and they're publicly available. And then 70% of a modern lawyer's job is statutory interpretation, to try and give effect to the intention of Parliament via the legislative tool. And of course, the courts are going to interpret the statute with a range of tools themselves that they've developed over time, and will give life to the intention of Parliament enshrined in the statute. And if Parliament doesn't like the way that's going, then they amend the legislation to pull the judiciary back into line. Got to remember the judges are unelected. So, okay, let's back up again, because we need to establish separation of powers so we can see the different parts. So, we've got 1066, William the Conqueror has invaded England. We've established a new legal system, replacing that customary or local ye olde law that was dotted around. England, prior to the William the Conqueror, was made up of a range of districts, which had a nobleman, sort of an elder, who had complete authority and decision-making powers over those districts. The king centralised public administration in England into a united country and sent travelling judges around the kingdom to decide criminal and civil cases. So imagine you're the king. I said you're at the top. You want to manage and administer your kingdom. How do you manage the power? How do you distribute and exercise your power over your populace? Well, you send travelling judges on horses around the kingdom, and they go to village A, and someone complains, oh, he killed my chicken. All right, well, 3 days in the stocks. And then you go to village B and they say he killed 3 chickens. All right, 9 days in the stocks. And there was a sense of continuity and common outcomes for common issues and common problems. Thus, the common law was born. So the judges wanted to apply the law fairly across the country as they rode around, and they developed a set of legal principles and processes to follow, allowing them to stand by decisions and previous decisions, and ensuring that justice was administered consistently across the country. And now this is now the doctrine of precedent or precedent that is still enshrined in the judicial hierarchy of courts, whereby a senior court's decision will bind a junior court's outcome if it's on the same matter, similar facts and similar circumstances. And we can see through the magical doctrine of precedent that it lays down reliability and stability, yet has flexibility to enable the judges to deviate from a preordained outcome by arguing that the current matter should be distinguished out from under the binding precedent of a senior court on its merits, because it's slightly different and it should have a slightly different outcome. So it's a magical thing because it provides certainty and assuredness as to probable outcome. However, it's flexible enough to be able to morph and bend to incorporate the nuances of the current factual scenario before the judges. So that's great, isn't it? It's like a malleable plastic. It's got form, but it is plastic, and it can adapt and incorporate current situation. So the doctrine of precedent is a big deal in our system. So, what are the working parts of a modern legal system? They normally have 3 different parts. We've got the legislature, the judiciary, and the executive. So we've already touched on Parliament being the legislature. The judiciary are obviously the judges and the courts, and they're the administration of justice. And then the executive are the power often the government of the day, who decide policy and structure departments, outcomes, process. So normally these three different parts are organised in a constitution. And when we say the word constitution, what constitutes a nation's power or legal system? Some countries have a written constitution. So Australia, the United States are probably two very famous written constitutions, which lay out the power and the division of power in a written document, a single source. And it's very hard to amend those. Whereas the UK enjoys an unwritten constitution, which is layered and complex, as there's no one document to refer to. However, it does have some strengths, as we shall see. So the constitutions will set out the systems of law, how it's got to be organised, and how each of its parts are separated, but also working together. So there's an interplay between those three. We have the doctrine of separation of powers, which tries to divide power again so that no one's got absolute power, and this provides some checks and balances on the other arms of government. So we, as I said, in the UK, there's not a single written constitution. There's historical development and established principles, such as the separation of parliament, judiciary, and executive functions to guide it. So parliaments, the legislature, are the lawmakers. They're elected by the citizens to govern us, but also to represent the views of the people, right? The laws are meant to be representative of the values of the population. All right, that's what they're meant to do, aren't they? They're to govern us, but we're governing ourselves via Parliament. So that's why we elect members of Parliament to go and represent our rights and argue them. And it's a great system because it has local representation at a national forum, and rights of individual communities can be prosecuted against the balance and the backdrop of the national interest and everyone else's rights. Obviously, with any fixed volume of anything, there's only so much to go around. There's only so many slices of the pizza. So in order to equitably distribute that, you have to have an eye on the whole. And Parliament, a representative Parliament, provides that function. The government is the executive, are institutions and public services that have the responsibility of the elected government and its leaders to deliver. So that's the procedural, operational arm, where we operationalise policy and government departments and the administration. And then finally, the third arm of a constitutional democracy is the courts and tribunals, also known as the judiciary. They're the decision makers who decide on disputes between individuals and between the state and individuals. So there's a lovely example of a balance and a check on the power of even the executive. So you may be Mrs. Smith and you've had a drama with the Department of X and you feel you've been unfairly treated. Well, that's an administrative law issue, and you can go and challenge the government's decision or the executive's decision on how they've administered your issue. And it needs to be lawful and legally compliant. And so it's a beautiful way of giving some power to citizens and ensuring that the executive and the government itself is not operating lawlessly and on its own will, but even the government of the day is bound by the law of the land. So it's a great doctrine, separation of powers. You split power up across three, and they can make sure everyone's in line. And you can imagine if you didn't. So you're not going to have blurs between those separation of powers. So they shouldn't influence each other, which is why judicial appointments should be apolitical. Yeah, because you don't want the executive to handpick the judges. Now, I'm not an expert on what happens in the US, but I know it's much more politicised, this Supreme Court judges and their tenures. And look what's happened. It's been stuffed is a strong word, but rigged or selected in a certain political view, to a right-leaning fundamentalist view that has anti-abortion sentiment, and you can upset the apple cart. I'm talking Roe and Wade, the current debate around American women's reproductive rights. And that's a lovely example of what happens if you don't have ultimate separation of power. You can blur the lines a little bit, and they lose their ability to operate checks and balances on each other. So, we've said the courts will decide disputes, and ultimately that is their role. They can't defer a decision and not generate an outcome. That is their role, that is their function. And I touched on that last time, that I don't know is not good enough. There has to be a yes or a no. You have to decide one way or the other the way the law is going to go. And it's a great, another peg in your legal landscape. The law's benefit for providing certainty. And if you think about the law as definitions of concepts and then thresholds, are you in or out? That's not a bad basis for your legal jigsaw, because that's really what's happening. It's a defined system of logic, using defined terms and then a structure. And I don't know is not good enough. There is an answer to everything in our legal system. So the first function is to make a decision. That's really their main function. But as I said, their secondary function, and the way they often do that, is to give meaning and interpret to those statutory provisions. And due to the proliferation of statutes the last 30, 40 years, and the shrinking of the common law, so common law over here, Parliament over here. Parliament has been just legislating phenomenally, certainly in the modern last 50 years. And because of the doctrine of supremacy of Parliament, parliamentary sovereignty, it takes precedent. And the courts, therefore, necessarily are constrained by parliaments. So our common law system, which is both judges and legislature, and it's the interplay of that. But what we are finding is a massive increase in legislation in jurisdictions around the world, regulation essentially. Governments are getting much more, or they're regulating more and more thoroughly, and slowly overriding explicitly the common law doctrines. However, there will always remain judge-made law, because that is a third of the constitutional operation of that jurisdiction. And so they make decisions and they interpret the legislation. So there's a huge role of the courts, and there always will be. So who else have we got? We've got police and public officials. They investigate and enforce the law against citizens. We know lawyers and barristers are personal representatives of citizens and legal entities. I should point out at this point that legal entities can be people and corporations and the government. So to then be sued and to be able to sue. So don't just think people, think anything with a legal entity, like a business that's incorporated. A government department. And we have lawyers and barristers, or solicitors and barristers. Solicitors usually deal with the public and then instruct barristers who have higher rights of audience, certainly in the higher courts. Solicitors used to not appear. I think there is some movement in many jurisdictions giving solicitors rights of audience in courts, but traditionally, and I think certainly at the senior courts, the solicitors deal with the public and then instruct a barrister who write opinions and do appearances before judges in courts, and they have rights of audience to do so and are trained in those protocols. And as I touched on in the introduction, a best place to argue the merits of their client's individual matter before the courts. That's the adversarial system that we have. So we've got, that's the structure, okay? Governed by doctrines of separation of powers is one, and parliamentary sovereignty as another examples. Now, we did touch in that human rights video on the rule of law, and there are enshrined in practice just certain rules and ideas. Now, we're moving a little into jurisprudence here of the sort of legal philosophy, but very briefly, a very brief introduction to jurisprudence would be a notion of natural rights and inherent. Now, these came originally via religious texts. St. Thomas Aquinas' Summa Theologica was probably the first classical statement of a natural law theory. And Thomas Aquinas felt these were God-given rights that were then represented through man and people. Inherent rights, like right to life and etc. And that gave birth to a field of jurisprudence called natural law. And we saw in the video, after the horrors of the Second World War, the establishment of the United Nations laying down the seminal document, the Universal Declaration of Human Rights. And that was an attempt to give natural rights, inherent rights, globally, to prevent the horrors of a world war and to prevent countries invading other countries ultimately, but just to set a floor on basic human rights that treaty member countries signed and agreed to give effect to in their jurisdictions. So that's a lovely example of a natural law theory, all right, or natural law. At the other end of the jurisprudence spectrum is legal positivism, legal positivists who claim it's got nothing to do with God or inherent woo-woo. What are you talking about? Where are these coming from? So legal positives are much more, no, we just write a set of rules and it can be whatever you like. You can ban the colour green if we all agree to do that. It's got nothing to do with inherent anythings. And that's a bit like the Monopoly board game rules idea that I introduced to you before, that you can set your own policies, you could make that it's $1,000 when you pass go or no dollars. I mean, you can literally write what you like. And legal positivists would say, yes, absolutely. And the law is simply a codified expression of values, and it's got nothing to do with inherent natural anything. It can be anything. And it gained favour in the earliest first half of the 20th century and 20th century. And of course, an example of clean or hard positivistic law would be Nazi Germany legislating to outlaw Jews. So the legal positivism fell out of favour after the Second World War as lacking any moral, natural, human, inherent rights. And of course, what happened was positivists became less hard and became soft, and natural lawyers became less hard and became soft, And now the two legal philosophies kind of meet in the middle. So you had the HLA Hart, Oxford Don, was probably one of the famous positivists. There was some Jeremy Bentham, who had his body stuffed and mummified and put in University College London. It's still there, would you believe? Jeremy Bentham and John Austin, who was Bentham's student, they were huge legal positivists, feeling that no, this sort of mystical and human-based interpretation of law is too unreliable. So courts of equity, trying to give out fairness, and there's a famous quote in equity that, your decision is based on the length of the Chancellor's foot. It's random, it's varied, and positivists were worried about natural lawyers. Positivists wanted certainty and firmness. So we have, Bentham, John Austin, and then HLA Hart, who probably Hart reconciled hard positivism and came much softer towards the end of his life, and had some great debates with Lord Devlin, for example, in the law journals around which set of laws should. So legal philosophy now is much more centralised in that we try and give effect to natural law rights, but we acknowledge it's through a positivistic system. But you can still be up in front of a judge who's very natural law focused. And you kind of need to know that, don't you? Because then your arguments can be much more grounded in sentiments of rights and fundamental freedoms and inherent, natural justice. Whereas if your judge is a legal positivist, if it says do this on the tin, then that's what he's going to do, right? Or she's going to do. So it is kind of important to understand that jurisprudence landscape. Hence I've touched on it briefly this morning. So we have parliamentary sovereignty, supreme to the courts. They can either agree what the common law judge has said and codify that in future legislation, or they can overrule specifically what the courts have done and say, no, we're going to change the legislation, in the interest of doubt. This means that, to avoid, in the interest of avoiding doubt, X, it means X, not Y as it's being interpreted in the courts. So the legislature can pull in the courts, pull them back because of the sovereignty of Parliament. Judge-made law will grow and develop slowly through the doctrine of precedent and can emerge new doctrines, the law of torts, the new tort negligence, and that was a common law creation. And then Parliament can say, hang on, we need to legislate this area. And then Parliament can also come up with whole new areas and codify and regulate entire new areas that have never got to the courts. Think nanotechnology, for example, a whole new, or GM crops. This is a brand new technology. It needs regulating. The courts are inherently slow and laborious, and you need an issue that's live and someone's willing to litigate and fund it for it to get up in front of the judges and get a decision. So the legislature can just come on in and say, right, here's a statute to codify the regulation of GM crops in agriculture. So the beauty of our system is that if there's a need, there can be a legal solution. So, other recognised sources of law include delegated legislation. So that's where Parliament legislates, doesn't want to get in the weeds of the granular day-to-day, so might give power down, delegate power to an inferior body and give them power to generate micro rules. So the good example is parking. Give local authorities authority to make more rules about who can park where on a Sunday, whereas the parent statute doesn't want to get into that level of detail. So it delegates down the power to others, and you might come across this term of a body acting ultra vires, beyond the power that they were given. So whenever interpreting delegated legislation, it's critical to check that the delegating body had power, and then the exercise of that power is not beyond the scope of what they had authority to do. Otherwise, you can claim and strike down that bit of the delegated legislation that is ultra vires, that is beyond the power that they were ever given to legislate. There's international law, sources of law. We have international law, often treaties. A lot of international law is now governed by treaties where countries would go and agree to certain things, think climate change, and sign up. Now, at that point, international law has no impact at all on a national level. And what happens is each member needs to come home and give effect to that international law obligations in their own domestic law, often through an act of parliament and generation of legislation. And that's to give effect to those international agreements, because there is no global world order. There is no global police. There's no global set of rules. Due to the notion of sovereignty in countries, individual sovereignty, whereby sovereign nations have the right to decide how they're governed. And obviously we need to respect sovereignty, because if you don't and you invade another, issues or disputes about legitimacy of sovereignty give rise to border disputes and wars. And again, that's back to power, isn't it? And having more power over more land and more resources and more people. So, due to this notion of national sovereignty, there is no global set of rules. So it makes things like managing global issues like climate change very tricky, because how do you enforce it? Can all agree, but then if one country goes rogue and doesn't keep their end of the bargain, well, what have we got? So it's mainly goodwill. It's mainly carrot, much more carrot than stick. You wouldn't invade a country, for example, for not, well, it has happened, hasn't it, for breaching certain standards, even though no evidence was found eventually. So, yeah, it can happen, but on the whole, it's national sovereignty is globally respected. Autonomy, national sovereign autonomy is respected, and people don't invade you to make sure you keep up with your emissions targets. We respect each other better than that. So, now we know where different types of laws come from. Let's have a think about different categories of laws. We've got laws that operate between individual members of the community or businesses, and to control and use between each other, and they'd be known as private law. So that would include contract, tort, intellectual property law. It's a way of defining it is private law issues between private citizens or corporations. The state uses to set and maintain standards of behaviour and conduct between itself and citizens, and that would be known as public laws. So again, that would be Mrs. Smith not happy with her Department of blah blah's decision on her claim. That would be a public law issue. And that would include criminal law, because criminal law, the two parties involved is the alleged accused and the state. So criminal law is interesting. We'll look at that at another session, because it's the state versus the individual. How do we change the law? Well, like all things, the law could become outdated. And remember, we said that the laws are meant to represent the values and the views of the citizens that it governs, right? So if our views on single-sex marriage change over generations or over time, and the laws are out of step with that, the laws need to change because the people have changed and views have changed. So how do we do that? Well, it's necessarily a slow process. Um, and a criticism would be knee-jerk reactions, wouldn't there, by the government of the day? We're getting tough on crime and tough on the causes of crime, maybe before an election. And there's an incident and there's a knee-jerk reaction and quick legislation to cover that specific type of issue, which is actually quite rare. And so the law is necessarily conservative. And here's an interesting point, isn't it? That it is flexible, it is plastic, it can bend and amend to the views of the day, but we don't want it too plastic or flexible because then you've got no certainty. So there's a tension between being adaptive to the views and the changing, evolving landscape of technological advancement and value shifting versus conservatism and, well, we don't want to change too quickly because, people need certainty and reliability and they've built things and they've got structures and we don't want to upset the apple cart every 5 minutes. How would society function? So there's a real tension there. And it could be a frustrating tension, and it has been said, I've framed it as the law is a limping dinosaur chasing the ferret of reality, because the dinosaur is slow to change and it takes time. But the older I've got, the more I've learned to respect the necessary slowness and conservatism of the law. But it does, in the gap between what people want and where we're at, as that moves, in the gap is injustice, isn't it? In the gap is same-sex couples who can't get married, or someone who's got a conviction for homosexuality because it used to be unlawful and we haven't quite matured as a society or got our act together to get legislation in to expunge convictions for out-of-date laws. So that's a gap. The gender issue, so whilst things change, there is a little injustice while people wait for the law to catch up with the views and values of society. And that's hard, A gay judge, their partner doesn't get the pension rights, for example. It was Justice Kirby was arguing for that in Australia for a while, and then that eventually got changed because he was loud enough and noisy enough and banged the drum. And rightly so. Why should his same-sex partner be discriminated against just by virtue of a gender? It doesn't stack up and it doesn't accord with the values of the community. So the law was eventually amended, but there would have been scores of other individuals who missed out on those benefits and rights and recognition prior to that amendment. So we need champions of change. We need people to push for justice, to end injustice. And we do that by banging the drum, writing a letter to the editor, getting involved, writing to your MP, hustling, making it happen. And eventually someone will put up a bill to Parliament, and that'll get debated and, if successful, enacted and then voted on and passed and receive royal assent and become law. So it's slow. It often, as I just said, occurs only after the harm has been felt by the community. Often it's better if new statutory laws are passed by Parliament in advance to try and keep pace with new problems and avoid uncertainty and cumbersome process that the common law can have. Law reform is the process of Parliament asking, listening, planning, researching and acting on calls from the community for change to how the law functions and impacts their lives. Law reform can be initiated by a number of ways, such as the public wanting a consultation process. So that often law reform commissions are set up and there are law reform bodies. and there are lobbies that agitate for law reform. So we have consultation there, great, and you might find in your area that you're interested in, there's been a law reform report on that area, and they're great because they get together experts, public, people in the sector, and they get all that information and then analyze what are the issues, what's working, what's not, and often come up with recommendations. And then it's whether the government of the day implement those law reform recommendations and become law. But as I said, if you're interested in a particular area of law reform and cutting edge of new laws, then if you can research and locate a Law Reform Commission report on that area, even if it's a bit old, it'll still be a very good collection up to the date of publication of exactly where they were on the cutting edge at that time. And forward-looking as well, because they'd make recommendations as to how to improve the law in that area and whether they're implemented, whether there's the political will by the government of the day or not. They're still very learned reports and documents that of high value. Sometimes there's a vote or a referendum is held to decide what direction the law should take. In Australia, we had the same-sex marriage referendum because no government had the political will to change the law because they didn't want to upset the conservative members of the community who probably didn't want to change the law because it didn't bother them. So rather than lose office, they just put it to the people, let them decide, and then there's no political backwash. If anything, you could claim you're listening to your population, a political win. There can be an inquiry held after a particular issue or an event that happens that the community's concerned about. New types of crimes often happen that way. Someone tragically dies through a situation, and then parents agitate for, Sarah's law or something to try and stop it happening again. So that's some examples of how citizens can actively get involved and influence and participate in the democracy and the democratic process, influence how the law is formed and ultimately passed in Parliament through their elected representatives. There are other ways you can get involved in law reform. Speak to your local MP or social media, get a profile and get people behind your message and your interest. All right, so we've covered a lot. We've covered William the Conqueror, 1066, feudal law, power, own it with loyalty and have a little tax. Then we had and the birth of the common law as judges toured the kingdom trying to give common judgments to common issues. That also set up certain pleas of choices of actions, they're called. And what happened was, in order to make your claim, your issue had to fall within a certain narrow scope of a claim, a chose of action, a cause of action. So you can imagine if your chicken was stolen, well, that's a common thing. You could claim and petition the King's Court for relief for the stolen chicken. But they were very narrow, these choses or claims of action. But essentially, the common law courts broadened slowly over time different causes of actions you could bring and complaints in front of the court, and they were then divided up into different divisions. We've got the Court of the Common Pleas, the King's Bench, the Exchequer. We had the Court of Chancery and Equity. Now, while we're here, I probably need to mention this briefly. So we have the law, which is like the hard law, and now you've got some understanding of jurisprudence. It would be a positivistic view of the law, the rules, right? It says blah, blah, blah. If the strict application of the law as it stands would result in an injustice, so something contrary to this positivistic law that was contrary to natural law, so against themes of natural justice, of which there are many, aren't there? They're like natural justice, things like, well, you can't accuse someone of something without them knowing it. People should have a right to defend themselves. People should have the right to go to court. People should have the right not to be held in detention indefinitely. People should have the right to transparency. People should have the right to silence, if they want, to not incriminate themselves. Rules should be clear and unambiguous. They can't be soupy or gloopy. How are you going to know if you're in or out? There should be no retrospective legislation. That's not fair. You can't change the rules yesterday. My conduct yesterday was lawful and now you're retrospectively changing it. So that's against natural justice, isn't it? So there's a plethora, and we might get to those. And this is how that's a lovely list of some of the tools the courts use to interpret legislation. So, well, hang on. Yeah. So that's natural law, and that's the rule of law as well would be encapsulated in these sort of natural law rights around, well, everyone should be equal under the law, and that's why you can impeach a president, right? No one's going to be above the law, as we saw with the Magna Carta. So if the strict application of the law, the positivistic law, this side, would give rise to unfairness and inequity, and some old lady losing their house is often the case. I'm thinking Lord Denning in High Tree's house. Then the Court of Chancery and you could call on equitable principles. And equitable principles is the court of equity, where equity can provide relief to an otherwise harsh outcome. Now, you can hear now Jeremy Bentham and these other positivistic lawyers screaming, well, what on earth? What do you mean? And where's this come from? And how can this be law? Whereas your natural lawyers would be like, well, we can't leave someone homeless because of blah, blah. That's, not right. She's got no fault on her hands. So you could invoke equitable principles to ameliorate otherwise harsh, strict legal outcome. Now, even explaining it, it does sound, it is a bit woolly, isn't it? And you can understand why legal positivists can't. Well, it's a little bit open to negotiation. It adds a whole layer of variability to an otherwise certain system. But so let me give a quick example. So in Lord Denning in High Tree's house, a lady was going to lose her flat, and the landlord was going to, they was given rent relief during the Second World War, and then they were going to put it back, but it would have been wrong to backdate that Hoik in increased rent to the period before. So Lord Denning famously invented, gave voice to, and again you can hear the positivists jumping up and down going, what is this? Where was it before? So he invented or gave rise or gave vision to, or the voice to, the doctrine of equitable estoppel. And the doctrine of equitable estoppel is this, that if you make someone a promise and they rely on it to their detriment, then you are stopped from going back on that promise. All right. So now there are some rules to invoking equity. This Court of Chancery, this sort of gentle, I'm thinking church and state. I think it's more out of the church and that sense of fairness and justice prior to church and state properly being divided. So there are some rules to invoke equitable doctrine. 1, you can only use equitable principles as a shield, not as a sword. So you can't go after someone using an equitable doctrine. And two, you must come to the court with clean hands. So you can't invoke equitable doctrines if there's any fault or mischief on your behalf. So it's reserved for the innocent and those who are facing an injustice. So you now understand that we have a legal system, and within that we have strict laws, but there's also equitable principles, all right, and equitable doctrines that are as strong as laws in that they can amend outcomes. So I think to give you an overview of the common law, we'd have to mention equity. So these choices of actions within the common law courts, so an action on the case gave rise to a lot of the torts case law on the action, an action on the case. There were certain causes of actions that you had to narrowly fall within. Otherwise, you had no right to relief. Nowadays, you can claim issues under statute. There are whole common law doctrines that exist that you can bring a cause of action: breach of contract, trust law. It's very broad. And if someone's acted unlawfully, you can petition the court for relief. You no longer have to fall within narrow choices of actions. But I suppose historically we need to understand that there were themes or streams of causes of actions which gave rise to all these doctrines of laws that have developed over time. So we've learnt that the judge-made laws have developed over time. They're bound by the doctrine of precedent to give them some certainty and scope. And if the facts are essentially the same as a previously decided decision, then the outcome would also be kind of preordained in that a junior court will be bound to follow the decision of the more superior court. You're only bound by decisions of your superior court in your jurisdiction. However, we also have, so they would be binding cases, but we also have persuasive cases. And that is cases which aren't technically binding, and that might be by virtue of jurisdiction, but they deal with similar issues and they have a bit of authority. And it's only persuasive authority, it's not binding authority, but this is where we can use a bit of international law, certainly within the common law system. So in the UK, you could find a case in America or Canada that deals with a similar issue. Now, that wouldn't be binding on a UK court. Why? Because of sovereignty, national sovereignty, and the UK has reserved the right to make its own decisions in law. However, out of a notion of judicial homity, of paying homage and respect to other judicial officers around the world, the case would have persuasive authority. And here's the thing, the more higher up the hierarchy the case is from that jurisdiction, be it Canada or the US or Australia or New Zealand or any other common law jurisdiction, the higher up that is, the more it's respectful, well, the more persuasive that argument would be, wouldn't it? Because a very senior court in another similar jurisdiction has come up with this outcome. And you can argue your case quite strongly. Now, the court, again, is not bound to follow it, but would be persuaded. So that was the evolution of the common law system of judge-made law, and it's complex, and it's great, and it's historical, and it's got, the merits of the case has been argued over and over by interested parties. Literally, the issue was on the line, and judges have given careful judicial reasoning, bright people, often ex-barristers, who've given this considerable thought and expertise and have come up with a reasoned outcome that might be appealed, overturned with more learned thinking, and we ultimately end up with the law as stated at a high level. And I suppose one other thing we should touch on briefly is a notion of a ratio and obiter. So when we have a case of judgment, in there hidden is the ratio decidendi, which is like the rationale. It's the real, if you had to simmer it down to the caramel, what is the ratio? Because it's only the ratio of the case that's binding. So we might have the ratio is when, the ratio in High Tree's house is that when someone makes you a promise and you rely on it to your detriment, they're stopped from going back on it. That's the key of that case. Ratios are binding on junior courts. That's it. Often when giving a judgment, a judge will say, oh, by the way, we're dealing with dogs, but if this was cats, I'd be inclined to decide blah, blah, or I'd be inclined to think this. All those, by the way, comments are known as obiter dictum. They're sort of talking around the issue. Now, they're not binding either. So it's only the ratio of the case is binding on a junior court. However, obiter is helpful. They're judicial pronouncements about the thing that you may well be able to use in future cases or issues in front of the court to say. And again, the more senior the judicial body making those obiter comments, the more persuasive that authority becomes. So common law space of judge-made law, huge, vast, hundreds of years old, well thought out, established doctrines, but because of the doctrine of parliamentary sovereignty and supremacy, legislation could come in and either affirm, change, incorporate, codify the common law, replace it, and say, no, this is the law from now on. Okay? So we have a beautiful interplay between judge-made law, legislation, but ultimate parliamentary sovereignty will mean that the legislation trumps the judge-made law. But of course, who gives effect to it? Back to the judges. So it's like a dance. All right, so we've learnt also that we have international law that sits out there in other jurisdictions that we can interact with, but unless we give it effect, and in domestic law, often through legislation, then it doesn't have any real teeth or effect in our legislation, in our jurisdiction. Okay, we have the separation of powers to keep checks and balances on different parts of our constitution. We have an unwritten constitution in the UK, and we have democratically elected members of parliament to represent the views of the people, which necessarily is going to be a little in front of our laborious common law beast, which is necessarily more conservative and slow. And in order to effect change, we can invoke and excite to get law reform and reform commissions and individual bills up in front of Parliament to change the future direction of the law. All right. Thank you very much for listening. We'll see you next time, where we'll explore the law of contract or private obligations and agreements. Thanks very much.